Welcome to this comprehensive presentation on California Adventure Sports Liability for 2026, presented by Asterisk Legal. The central question we will explore today is, when does a waiver fail against gross negligence? California's adventure tourism industry generates over $58 billion annually, with millions of participants signing liability waivers every year. Yet when tragedy strikes, those waivers face their ultimate test in California courts. This presentation will provide operators, legal counsel, insurers, and adventure tourism professionals with a comprehensive analysis of the California liability landscape. We will examine the foundational statutes, landmark court rulings, the critical distinction between ordinary and gross negligence, and the practical compliance framework every operator must implement for 2026. Part 1. The landscape. California's adventure tourism industry is a $58 billion economic powerhouse. From rock climbing in Yosemite National Park to ziplining through the ancient redwoods of the Santa Cruz Mountains, from whitewater rafting on the American River to hang gliding over the Pacific coastline, millions of thrill seekers participate in adventure sports across the state every year. Almost all of them sign liability waivers before they begin. These waivers are the first line of defense for operators against legal claims. But when a participant is seriously injured or killed, and the operator's conduct crossed the line from ordinary carelessness into conscious disregard for safety, California courts have consistently held that the waiver provides absolutely no protection. The numbers tell a powerful story. California's adventure recreation industry generates over $58 billion in annual revenue. More than 14 million participants take part in adventure activities across the state each year. Over 200 waiver-related cases make their way through California courts annually, and the average gross negligence award in these cases exceeds $2.8 million. These statistics underscore the immense economic and legal stakes involved. Every waiver signed, every safety inspection conducted, every training session completed is a potential turning point in a future lawsuit. Understanding when waivers hold up and when they crumble is essential knowledge for anyone operating in California's adventure sports industry. Part 2. Statute and Precedent. Understanding California's waiver enforcement framework requires mastery of two key pillars. First, California Civil Code Section 1668, the foundational statute that has been on the books since 1872. Second, the California Supreme Court's definitive formulation of gross negligence from the 2007 case City of Santa Barbara versus Superior Court. Together, these two authorities establish the legal foundation that every adventure sports operator and their counsel must understand. As stated on the official California Legislative Information website, leginfo.legislature.ca.gov, the plain text of Section 1668 invalidates any contract that attempts to shield a party from liability for willful injury or violation of law. And gross negligence, being a conscious disregard for safety, is treated as equivalent to willful misconduct. California Civil Code Section 1668 was enacted in 1872 and remains one of the most important statutes in California contract law. It declares that all contracts which have for their object, directly or indirectly, to exempt anyone from responsibility for their own fraud or willful injury to the person or property of another, or violation of law, whether willful or negligent, are against the policy of the law. California courts have consistently held that waivers purporting to release liability for gross negligence fall squarely within this prohibition. You can find the full text of the statute by following the QR code on this slide. The statute's language is clear and unambiguous. It reflects a fundamental public policy that certain conduct is so harmful to society that no private agreement can excuse it. For adventure sports operators, this means that no matter how well drafted your waiver may be, it cannot shield you from liability for conduct that crosses the line into gross negligence. The California Supreme Court's definitive 2007 ruling in City of Santa Barbara versus Superior Court, also known as the Estate of Sakai case, Citation 41 California 4th 747, established the controlling definition of gross negligence. The court defined gross negligence as the want of even scant care or an extreme departure from the ordinary standard of conduct. It is characterized by reckless indifference or conscious disregard for the safety of others. This ruling is the single most important precedent for adventure sports operators defending waiver enforceability in California. The case involved a tragic drowning at a city pool. But the court's definition of gross negligence applies broadly across all contexts, including adventure sports. What this means in practice is that a waiver will protect an operator who made a mistake, who failed to exercise ordinary care. But it will not protect an operator who knew of a serious danger and consciously disregarded it. Part 3. The dividing line. The distinction between ordinary negligence and gross negligence is not merely academic. It is the difference between a valid waiver that protects an operator and a void contract that leaves them fully exposed. Understanding where California courts draw that line is the most critical skill for adventure sports counsel. In the next slides, we will examine the exact definitions, compare the standards side by side, and explore what operational conduct falls on each side of this critical boundary. Let us compare ordinary and gross negligence side by side. Ordinary negligence is the failure to exercise reasonable care under the circumstances. It means the operator did something a reasonably careful person would not have done, or failed to do something a reasonably careful person would have done. Examples include a slippery floor that was not cleaned promptly, a minor equipment issue that was not caught, or a delayed response to a participant's question. Waivers are enforceable for ordinary negligence in recreational activities. On the other hand, gross negligence is defined by the California Supreme Court as the want of even scant care, an extreme departure from the ordinary standard of conduct. It requires reckless disregard or conscious indifference to the consequences. Examples include operating with known broken safety equipment, sending participants through dangerous conditions without adequate preparation, or ignoring known hazards because addressing them would cost too much. Waivers for gross negligence are void as a matter of public policy under Section 1668. The key question for any operator is, was this simply a mistake, or did someone know better and choose to proceed anyway? California courts apply 4 rigorous tests before upholding any liability waiver in the adventure sports context. The first test is clear language. The waiver must use plain language that specifically identifies the risks of the activity. Legalese and blanket all risks language will not suffice. The waiver must be clear and unambiguous. The second test is conspicuous presentation. The waiver must have bold headings, capitalized warnings, and a distinct signature block. A reasonable participant must actually notice the waiver. It cannot be buried in fine print. The third test is specific intent. The waiver must explicitly reference the operator's own negligence. General language about assuming inherent risks is not enough. The fourth test is the public interest test from the Tunkel case. The activity must not be an essential public service. Fortunately for adventure sports operators, most recreational activities pass this test, but failure on any single test typically renders the entire waiver unenforceable. Part 4. The cases. California appellate courts have developed a rich body of case law at the intersection of waivers and gross negligence in adventure activities. These landmark rulings provide the practical guidance that operators and their counsel need to understand what conduct crosses the line. We will examine 3 pivotal cases that every California adventure sports professional should know. The 2020 case Erickson v. Dowride Thrills LLC, citation 54 California Appellate 5th 1009, is a landmark ruling for the adventure sports industry. In this case, an amusement ride operator's waiver did not bar gross negligence claims. The court held that while waivers for ordinary negligence in recreational activities are valid, gross negligence cannot be waived under any circumstances. The key fact was that the operator knew of a dangerous ride condition and consciously disregarded it. This knowing disregard crossed the line from ordinary to gross negligence. For adventure sports operators, the lesson is clear. If you know about a hazard and choose to operate anyway, your waiver will not protect you. The 2018 case Haas v. Rodico Productions, citation 26 California Appellate November 5th, applied the ordinary versus gross negligence distinction squarely to adventure sports. This case involved a ziplining accident. The court held that the waiver was valid for ordinary negligence claims, such as inadequate briefing or minor equipment issues. However, the waiver did not bar claims that the operator failed to properly secure cables or operated in unsafe weather conditions. These failures, the court found, could rise to the level of conscious disregard for participant safety. The case demonstrates that even a well-drafted waiver has limits. When an operator's conduct demonstrates a pattern of ignoring known safety standards, the waiver becomes meaningless. The 1988 case Madison v. Superior Court, citation 203 California Appellate 3rd 518, is the foundational case that established the standard for waiver enforceability in California recreational activities. The court held that releases for ordinary negligence and recreational activities are enforceable, but only if they are clear, unambiguous, and explicit. The waiver must specifically mention the defendant's own negligence. It cannot be buried in fine print or obscured by technical language. This case set the standard that California adventure sports operators still follow today. The Madison decision created a clear roadmap for drafting enforceable waivers, but it also established strict limits. If the waiver does not satisfy every element of the Madison test, it will be struck down. Part 5. Action Plan. Knowing the law is one thing. Translating it into operational practice is another. In these final slides, we provide the practical compliance framework that every California adventure sports operator must implement for 2026. A well-drafted waiver is essential, but it is not enough. The only true protection against gross negligence claims is operational discipline that never crosses the line from ordinary care into conscious disregard. The Bulletproof Waiver Checklist. A waiver that survives California judicial scrutiny must satisfy every element of this framework. First, include explicit reference to the negligence of the operator. Second, provide specific enumeration of activity risks, avoiding blanket all risks language. Third, use a bold, capitalized heading that says read before signing. Fourth, place a separate signature line above all waiver text. Fifth, require parent or guardian co-signature for minor participants. Sixth, write in plain language at an 8th grade reading level. Avoid all legalese. And seventh, provide translation into the participant's primary language when practical. Missing even one element can expose the operator to unlimited liability in a gross negligence claim. Beyond the waiver, operational guardrails against gross negligence claims. A well-drafted waiver is essential, but it cannot protect against gross negligence. The only true protection is operational discipline that never crosses the line from ordinary care into conscious disregard. Here are the 7 guardrails every operator must implement. First, document every daily safety inspection in writing with timestamps. Second, maintain ACCT, PCI, or equivalent industry certification. Third, provide qualified trained guides and never use unsupervised novices. Fourth, establish written weather and environmental safety thresholds and follow them. Fifth, keep equipment replacement and maintenance logs with serial numbers. Sixth, conduct annual third-party safety audits with written reports. And seventh, train staff on the specific difference between ordinary and gross negligence so they know where the line is. The 2026 verdict. California's adventure sports industry operates in a unique and challenging legal environment. Here's what every operator must remember. Waivers are enforceable for ordinary negligence. If an employee makes a mistake, a waiver can protect the business. But waivers offer absolutely no protection against gross negligence. If an operator knows of a danger and consciously disregards it, no waiver in the world will save them. The distinction between ordinary and gross negligence is where lawsuits are won and lost. Operators who understand this line, draft their waivers meticulously, and maintain rigorous operational standards will thrive. Those who rely on generic waivers and cut corners will face multi-million-dollar verdicts that no insurance policy can fully cover. This presentation has been brought to you by Legal. Thank you for watching. For more information, scan the QR codes on this slide to access the full text of California Civil Code Section 1668 in the City of Santa Barbara decision.